A very good afternoon to one and all present here. We will start the third session now. So I request everyone once again to please keep your mics on mute and also switch off your videos unless you're speaking. Um, our first speaker for this session is Professor Anna Masuti. Professor Masuti is a tenured professor of air law, University of Bologna, Italy State University. Since 2006, Anna has been involved in the Galileo and EGNOS programs, and she is very active in the development of the main global navigation satellite system. She co-drafted a proposed EU legislation for third-party liability for the Galileo satellite program for the Italian government and a feasibility study on an international convention regarding GNSS presented by the Italian government to the European Commission and to the International Institute for Unification of Private Law. She is currently very active in the implementation of the Single European Sky and the CESAR programs. Ms. Anna is a legal advisor for the IBAA, that is Italian Business Aviation Association. She also advises the association in all the legal issues on financial and tax law aspects. She is on the board of the European Air Law Association, legal advisor in the IBAA's board, that is Italian Business Aviation Association, and officer of the Aviation Committee of International Bar Association. She is a regular speaker at international seminars and conferences. She is the author of various books and numerous articles on air and space law. I request Professor Anna Masuti uh, to come today and talk about the topic bilateral agreements and aviation market evolution, the state of play.
Thank you very much for your presentation. I'm really delighted to be here today with you and with a lot of friends, as I can say. And good afternoon and good morning to all of you. If I can see my slides, I immediately start my presentation. Thank you very much. As you said, I will talk about the bilateral agreements and especially the state of play of the current situation of bilateral agreements and mainly the opportunities that airlines are facing currently. It's difficult to say, but in the future, in considering the regulation that we have worldwide. So if we kindly go ahead with the slides, thank you very much. May we have the second slides? Good. So we know that our world, the aviation transport, is affected by the sovereignty principle established by the Chicago Convention. And we have seen, we face the fact that this industry doesn't have the same opportunities of other industries. And may recall here what the CEO of the Italian Fiat, the car manufacturer, that I quoted here. If you can go to the second slides. The Mr. Marchionne, the former CEO of Fiat, when they merged with Chrysler, said that it was a great opportunity for the Italian manufacturer to merge with an American manufacturer, benefiting from the possibility of exporting to non-European markets. And it was the opposite. It is the opposite also for American producer, and sharing the cost of developing architectures that will have a parallel application in America. But what I would like to quote here is another aspect, because Mr. Marchionne emphasized the fact that the globalization of the two companies is even cultural. And I quoted here his words. This generates opportunities for professional and personal growth as never happened before in the history of these two companies. And I think that in our field, we cannot enjoy the same common cultural, the same possibility for personal growth of new generations in our field. So we really need that something will change in our sector. But what is the concrete obstacle to this integration? And as we already know, in the next slides, we can see this is the nationality clause. This clause, that is the consequences, the concrete application of the sovereignty principle, which established that airlines has to be substantially owned and effectively controlled by the home state or its nationals, with the possibility to revoke a certificate or permit when one airline are losing its nationality. So this is something peculiar of our work, of aviation sector, which is not, which doesn't characterize other industry. And we have seen that during this period, this is in my, not only in my opinion, but we will see that this is also in the opinion of the European Union, the real obstacle for the airlines to have to enjoy the same opportunities of other industries. If we can go to the next slides, thank you. We can see that unfortunately this clause affect around 90% of the current bilateral agreements. But, next slide, thank you. We have an example of what is possible to obtain without the nationality clause, because European Union represents the real single European sky, which enjoys all the 9 freedom of the air. So we can talk about a real democratization in Europe and a real competition if you consider the possibility for airlines to expand, to operate in other countries different than the home country. If you think Italy, our major airlines are not Italian, but European airlines. Next slide, please. So the real question is, which organization can lead such a process or can do something that is already a reality in Europe? And the first, next slide, the first organization that we can imagine, which comes to our mind, is ICAO. ICAO that has among its task the development of international transport, preventing economic waste caused by unreasonable competition. But we know very well, next slide please, that this is a mandatory contradictory mandate, as we know, because of the wording of Article 6, which is not really clear, and we are having debates about the role of ICAO that is embedded to intervene in the economic issues. So if we don't have ICAO, what would be possible to do? Next slide, please. May we have other organizations capable of solving this problem? Maybe WTO. But, next slide, please. We know that although WTO has a quasi-universal international legal framework for trade relationship, our subject is relegated in a specific annex which doesn't recognize, negotiate. If we can return to the previous slides, please. Now, we have to return back to the WTO slides because we are at the end of the presentation now. Please go back. Okay, this is right. Thank you. No, number 11. This is perfect. So I said that ICAO regulates in a specific annex, which doesn't intervene in the connection of traffic rights, because of the principles which characterize almost all characterize the relationship in WTO, which is the most favorite nation. Principles which establish that all WTO members have to recognize the best treatment as a country grants to any other country on non-reciprocal basis. So it's extremely difficult to apply for the most liberalized countries these principles to other countries which not recognize the same traffic rights. So the freedom of the air. So we can conclude. Next slides. Please go ahead. Will it be possible to have the slides? Okay, very good. We can conclude that the two important international organizations, ICAO and WTO, are currently incapable to solve this problem. What we are having, and we have to consider the current situation to be realistic, are only regional solutions. And we are facing only regional solutions, and I would like to return to the European Union, and I kindly ask you not to use the microphone. Okay, very good. Please go ahead with the next slides. Exactly, and because the state of play of the current situation is this, the countries are adopting their solutions and the European Union is adopting its solution. I would like to emphasize the fact that the European Union during the lockdown stress again, return to these important issues, saying in its work program for this year, 2020, anticipated its intention to revise the ownership and control rules in order to support and to help to mitigate the airlines, in order to mitigate the consequences of COVID. I just would like to remind you that the European regulation of 2008 requires airlines to be owned and controlled by the majority of European citizens. Next slides, please. So the European Union emphasized the fact that it is important to intervene in this sector, amending this rule in order to adopt, and I quoted again here the words used by the European Union, a more relaxed approach. And this in order to increase globalization. Of course, that the European Union could start a path with member states in order to reduce the percentage of the shares in hand of the European citizens. But the real problem is, and still will remain, the relationship later on with the non-EU states, because the European Union doesn't have, apart from some exceptions, the external competence on this regard. So another solution adopted by the European Union is to prevent one of the consequences of the nationality clause that we have seen before, which is the protection of the states, the protection of their airlines, granting financial support and so on, infringing the level playing field. And in the next slides, we can see that the European Union, and we can go also in the final slides, the European Union last year approved. Go ahead, please. Approved a regulation 712, which established rules in order to prevent the violation of fair competition in Europe. And the regulation gives the possibility for the European Commission to start investigation and adopt the repressive measures related to the practice distorting competition between EU airlines and the airlines of non-EU states, applying also sanctions. The European Union, in this way, has the possibility to investigate distorting practices applied in Europe and to apply, at the end, sanctions against non-European airlines operating in Europe. We will see if this regulation will reach the results that the European Union has wanted to reach with this regulation, because we know that this regulation amended a previous regulation which remained, as we know, without any positive results for the European airlines. But again, I would like to stress that this is a regional solution adopted at the European Union level, and still we do not have a solution worldwide. Thank you very much for your attention.